Yes, Mr. Locke.
My Lords, over the lunch adjournment, we have succeeded in unearthing the 4th edition extracts from Koppel.
Right.
Those should be on the
Oh, we've got them here, have we? Yes.
desks in front of you. If Mr. Tabor is happy for me to deal with this just quickly, the relevant paragraphs are 2822 and 2824. My Lords will see that they are within a chapter titled Appeals, and they set out the conventional position in relation to the Commissioner and the exercise that the Commissioner and the FTT are carrying out. And so my submission, they don't take us any further with the question at issue in this appeal, which is what the public authority is doing, rather than later stages in the chain.
Right.
My Lord,
Sorry, I'm grateful to my friend. When, strictly speaking, I was asked to do this homework for sharing the results of the inquiry. Certainly, it says, as your lordships will see at the top of internal page 925, in relation to an appeal against a decision notice, it, like the Commissioner, must consider the factual position as it was at the date of the decision by the authority. Well, we would say that it applies a fortiori the authority itself, and not a subsequent date, like into reconsideration.
Right.
Sorry, just to add that in relation to that further material.
Yes.
My Lords, I had been about to set out the structure of my submissions. I'll do that very quickly. That'll be to look at the purpose of the directive and the regulations read in light of it, then to take you through my reading of the statutory scheme, and then I'll deal with what I said to the practical consequences of Mrs. O'Hanlon's reading. And the reason for looking at the purpose of the EIR is that the EIR, unlike the Freedom of Information Act, start from the presumption that disclosure of information, here environmental information, is a good thing. And they have a number of differences of wording and structure that reflect that different starting presumption. And from that I draw 2 points. The first is that the purpose of EIR is a pointer towards an interpretation that favours greater disclosure of information and that facilitates a more frictionless procedure for accessing that information. And I say that supports Mrs. O'Hanlon's interpretation of ground 2 in particular. The second point I'll draw is that you should not hesitate to arrive at a different conclusion under EIR than would apply for the equivalent provisions under FOIA if that is where the particular wording of EIR leads you. The regimes are different, both in their specific wording and in their overall purpose. So, my Lords, that's the point I want to make good, first of all. And I'd invite you to turn up the directive, which is tab 1 of the authorities bundle, starting at page 8.
Yes.
And these are provisions that, for the most part, Mr. Metcalfe took you through, so I'll try to take them quickly, if I may. But of course, I put a slightly different emphasis on them. Recital 1 sets out the underlying philosophy, if you like, that increased public access to environmental information contributes to more effective participation in environmental decision-making and eventually to a better environment. So there's a founding purpose set out in Recital 1 that more access to information will ultimately improve the environment. It's a desirable thing. Recital 5 refers to the Aarhus Convention, whose purpose is set out there in its title, includes access to information relating to the environment. And the directive implements that, of course. Recital 8 expresses the access right. I say in very general terms, it is necessary to ensure that any natural and legal person has a right of access to environmental information held by or for public authorities without his having to state an interest. So the right is simply to the information that is held. There's no temporal restriction placed on that right.
Or any restriction on standing, which of course outside the UK can be a massive issue in case this kind of...
Indeed.
Yeah.
That's a point I'll come back to. Recital 9 seeks to maximise the spread of environmental information. It's necessary that public authorities make available and disseminate environmental information to the general public to the widest extent possible. Recital 16 actually speaks specifically about what the purpose of the directive means for its interpretation. The right to information means that the disclosure of information should be the general rule. Grounds for refusal should be interpreted in a restrictive way. So the recitals make the point that I'm making to your lordships, which is that in light of the purpose, one needs to read the provisions of the directive in a way that facilitate that right. Moving to the operative part of the text, Article 1 sets out the objectives, and they are twofold. The first is access to information on request, I'm paraphrasing, and the second is active dissemination by public authorities without any need for a request. And those are regulations 5 and 4, respectively, of the EIR. So again, we see the objective of the directive, little a, is to guarantee the right of access to environmental information held by or for public authorities. And again, I say the right is to the information that's held without any temporal limitation on that. And again, just in passing, little b, which relates to the proactive duty, again, emphasises that it's desirable to achieve the widest possible systematic availability and dissemination of environmental information. So while that applies in terms to the regulation 4 duty, it's clear that overall the directive sees the widest possible dissemination of environmental information as a desirable thing. Article 3 is, of course, the source of the access right that becomes Regulation 5. And it states, Member States shall ensure that public authorities are required, in accordance with the provisions of this directive, to make available environmental information held by or for them to any applicant at his request and without his having to state an interest. Again, I make the same point that there is no temporal limitation imposed by Article 3.1. The words "at his request" merely indicates that the request is the trigger. And what they are doing is contrasting access on request or at the applicant's request with proactive dissemination, which doesn't require any request. I would invite you to note, my lords, that Article 3, like Recital 8, spells out that the requester does not need to state any purpose. And I'll come back to how that's figured in the regulations themselves. Now, my lords, those provisions are set out and analysed by the Upper Tribunal in the case of Vesco, which you have at tab 9 of your authorities bundle. The decision starts at page 238. But I'd ask you to go straight to page 244. Where the provisions of the directive that I've been referring to are set out.
Yeah.
At 246, paragraph 13 of the decision, those provisions are summarised and the Upper Tribunal comments on them by big G, in the margin. Another aspect of public participation is that the public should have access to information so that they can be informed about matters relevant to the environment and be able to take decisions accordingly. So that's another way of phrasing the presumption that the public should be able to access this information. Over the page 14, it's clear from the extracts from the directive set out above that the purposes of the directive include guaranteeing rights to access environmental information. Public authorities hold information on behalf of the public and are to support and assist the public in seeking access to information. And likewise, in my submission, the courts should adopt interpretations of the regulations that facilitate that access. And the second point is, as I foreshadowed, that the overall pro-disclosure stance of the EIR is a material difference from the Freedom of Information Act. And that's made express in paragraph 15 of VESCO. This background is why the terms of the EIRs are different from other instruments governing recovery of information, such as the Freedom of Information Act. And I'll just give my lords a moment to read paragraph 15. It says there are a number of differences. It gives two examples: no absolute exemptions and the presumption in favour of disclosure. Mr. Tabori says in his skeleton argument that I'm overstating the difference between the two regimes. But what the Upper Tribunal is doing in the VESCO case is saying the opposite. It's saying that
You had a list of 4, and here they've got the 2 most important. It may not make much difference.
the two most important for present purposes in that case. There are manifold. And the point at issue in VESCO was how that affects consideration of Regulation 12.4b, the manifestly unreasonable exception, and how the exercise of public authority has to undertake contrasts with what would be done under Section 14 of FOIA. And I won't take you through all the detail in paragraph 16, but just to note the final sentence of that paragraph over at page 248. There are therefore more hurdles to jump before a public authority may legitimately refuse a request for environmental information.
You're reading from
The very top of page 248, my lord, the last sentence of paragraph 16. And moreover, my lords, the role of the presumption in favour of disclosure is not, as Mr. Tabori suggests, simply limited to functioning as a tiebreaker. Paragraph 19 of VESCO, over the page at 249, we see that the presumption serves two purposes. The first is the tiebreaker. The second is to inform any decision that may be taken under the regulations. So it is of more general effect than simply acting as a tiebreaker. And the reason for taking you to these differences, my lord, is to make good my submission that you should not assume that a broadly equivalent provision in FOIA would give rise to the same legal result. And in fact, you shouldn't even assume that the same words will mean the same thing across the two regimes. And I say that on the authority of this court's decision in the Montague case, which had to construe section 2.2b of FOIA. And if we could just turn that up quickly at page 295, the authorities bundle. You see that section 2.2b, in all the circumstances of the case, the paragraph, we are within paragraph 7 of the Montague decision, setting out section 2 of FOIA. And within the quotation, section 2.2b, in all the circumstances of the case, the public interest in maintaining the exemption outweighs the public interest in disclosing the information. And those are the same words as Regulation 12.1b. But at paragraph 46 on page 311 of the bundle, Lady Justice Andrews dismissed the suggestion that the way that Regulation 12 had been interpreted.
Justice Lewis, I think.
Oh, forgive me, are we still in the decision? We are, indeed. Apologies to court.
Who had been counsel in Ofcom.
Yes, I believe that was correct. But was unimpressed by the suggestion that the way those words had been interpreted within Regulation 12 of EIR was any guide to FOIA, given in particular the need to read EIR in light of the directive. Now, in the present case, the point of comparison of legislative text arises primarily under ground 2, and it's the comparison between section 1.1 of FOIA and regulation 5.1 of EIR. Because Mr. Tabori relies on the interpretation of section 1 of FOIA by the High Court in OGC. My lords, you have the points from my skeleton that is obiter, it's not binding on this court, and moreover, no one seems to have pointed out section 1, subsection 4, which determines the question expressly. FOIA makes particular provision that the information in question is the information held at the date of the request. But more importantly, I say, is that the words say different things, so that OGC is not even persuasive in relation to the question that you have to construe about the time of holding under EIR. We have section 1 of FOIA, page 2 of the authorities bundle. And one can see simply from its structure that it creates two distinct rights. And the scope of the second right is defined by reference to the scope of the first right. So to unpack that a bit, little a, the first right is to be informed in writing by the public authority whether it, the public authority, holds information of the description specified in the request. We're told, as it happens by section 1.4, that must mean the information at the date of the request. And little b, the second right, to have the information communicated, is a right that attaches to that information, i.e. the information that's been identified in section 1.1a. So the disclosure right under FOIA attaches to the information that's been identified by the public authority at the point of the initial response, but in fact we're told by FOIA expressly that it's the information held at the date of the request. And in the absence of any statutory review procedure, the disclosure right under FOIA remains pegged to that information. So you don't, in my submission, derive any assistance from that, and apologies for the excursion, other than by way of contrast with your task of construing Regulation 5.1 EIR, which is in much simpler terms. You have it at page 22 of the authorities bundle. Regulation 5.1 states that a public authority that holds environmental information shall make it available on request. Now, I say that consistently with Recital 8 and Article 3 of the directive, there is nothing in the wording of 5.1 that pegs the time of holding to the date of the request. The words on request here simply mean that the request is the trigger for the duty.
It does imply that they hold it already before the request comes about.
Well, my lord, I don't accept that.
This is a matter of ordinary English. They make available on request that which they hold.
But that's not what it says, my lord. A public authority that holds environmental information, present tense, shall make it available on request. And all I say that on request is doing is indicating, as I said, that the request is the trigger. It is indicating the distinction between Regulation 4, no request needed, and Regulation 5.
That holds or will hold. I mean, if you take the request as a trigger, it must be triggering something. And the way you're reading it, it triggers an obligation to provide information which they don't yet hold.
Well, it triggers an obligation to make available the information that they hold. But a decision on that is
That's
only...
the way I was reading it.
Yes. But a decision as to whether what that information is and whether it should be made available is only taken at some subsequent point by the public authority.
So could a request ask for information which you now have or may acquire in the next 6 months?
A request could ask for the latest statistics on badger culling, and because if the public authority then came to hold information at the date it is deciding whether or not to make that available, the terms of that request would include anything that was held at the time that the public authority was taking that decision. But that's the most express example, but probably the most common example is the form that we have in this case. Please can you give me all information that you have relevant to topic X? Now, all information...
That you have or will have?
No, that you have.
You have.
But that you have or will have at the time of the request or will have before the request is finally determined by the any conduct of a review of the decision, of any initial decision reached.
Unpacking it, you could put it like that, my lord, but I say that is
This isn't
necessary.
what the regulations actually say, but that's the inference you draw from your construction of the regulations, that it's a continuum, to use my lord's articulation of it, it's a continuum within which this duty continues to arise.
Yes, and that is what's conveyed by the present tense. That's what's conveyed by the present tense, my lord, of holds.
So it's a bit like Regulation 4, it's a duty to progressively make the information available, even though progressively doesn't appear in Regulation 5.
No, I don't suggest it's a duty to progressively make it available, my lord. It's a duty to, well, the duty is to make information available that you hold. The point at which you discharge that duty is when you take the decision and either disclose or refuse. And that's the date at which my learned friends accept you judge the public interest balance, for example. Now, I say that's correct because the public interest balance and the prior step of whether the exception is engaged are expressed in the present tense. Does an exception apply? Does the public interest in withholding outweigh, present tense? And all of those things are matters that you consider at the point you come to discharge your duty. And the same thing applies to the question of what information you hold, because the duty is a duty to make information available that you hold.
Right. Well, no doubt you will explain how Regulation 12.4a fits into that. B, is it? 12.4a. But we'll come to that, I'm sure.
Yes, and so, as I say, my lords, the words "on request" are not doing the work of pinning the time of the holding requirement, as my learned friends suggest. They're simply marking the distinction of Regulation 4, and they're also, in my submission, conveying the stipulation in the directive that the applicant has no need to state an interest, because that does not find any direct expression anywhere else in the regulations. So I say it, on request must be also be doing that work. And in effect, it conveys something like, for the asking. The applicant can have this information at his request and without having to state an interest, on request. Merely for asking. And I would note that Regulation 5.4 provides a further pointer in support of that interpretation, where the information made available is compiled by or on behalf of the public authority. It shall be up to date, so far as the public authority reasonably believes. So that is indicating that at the point of making the information available, certainly for information the public authority has generated, it's required to ensure it's up to date. And that, I say, supports my reading that the relevant date for the holding requirement is the date of that, when the duty is discharged. So, my lord, that's the first stage in the statutory scheme, although it relates in particular to ground 2. I want to move on to the public authority's duties if it wishes to refuse a request, which is relevant to ground 1 as well. So as Mr. Metcalfe said, setting aside the Regulation 13 provisions relating to personal data, the exceptions to the duty to disclose are Regulation 12, that's page 30 of the authorities. And as we've seen under subsection 1, there are 2 conditions that must be satisfied. First is that an exception applies, and that's phrased in the present tense. And if we look at the exceptions, they indicate that it's the then current situation that falls to be considered. And that is common ground, at least as far as the original refusal goes. As I propose to park dealing with Regulation 12.4a, I'd prefer to come back to that once I've been through the rest of the regulations and set out what I say is the proper approach to the exceptions. The one thing I would say at this stage is that I don't share the general consensus that emerged before lunch, that 12.4a applies as at the date of the original request. Of course, it is applying by reference to those circumstances, but you still have to apply it as at the date you're taking the decision as to whether to make information available, because you would have to have some information on which it could bite. So you would need to ask yourself, do I now have information which I didn't have at the time of the request? So you are applying the exception, like all of the others, at the date you take that decision, albeit that this is a uniquely backward-looking exception. And I'd say that now, my lords, without prejudice to my submission, that in fact Regulation 12.4a doesn't make any sense. That you should strike it down, but I'm going to come back to that. But if we look at all of the other exceptions, and this is common ground, so I'll take it quickly. They indicate that it's the current situation that's to be considered. For example, 12.4d, material which is still in the course of completion. It would be odd if you could refuse to supply information that had in fact been completed at some point between the date of the request and the date of the refusal. That would not make any sense, and none of the parties suggest that you can do that. Likewise, all of the Regulation 12.5 exceptions consider the effect of disclosure. And in my submission, it makes obvious sense to consider that effect at the date when disclosure would otherwise take place, the date of the refusal. So a public authority thinking about whether any exception applies.
Is it I understand that you say it's the date of the decision. Is it the date of the decision or the date when by when the decision should have been given, if earlier?
I say it's the date of the actual decision.
Even if later than the date when it should have been given by?
Yes.
So there's a difference between you to that extent?
Yes, my lord.
Thank you.
Because it's the discharge of the duty, even if late, that gives rise to everything that I'm saying. And my lords, I make essentially the same submission about the public interest test. Again, that is framed in the present tense. If the public interest in maintaining an exception outweighs present tense that in disclosure. So this is all common ground, and all I would note is that on the appellant's case, a gap has already opened up between the date at which they say the held requirement applies, the date of the request, and the date at which the public interest test is to be applied in the first instance, the date of the refusal. And so any public authority, even on the appellant's case, would be hostage to the very issues that Mr. Metcalfe complains about in the scenario where my construction of Regulation 11 is correct. I.e., if there is a change of circumstances on day 18 of 20, then a public authority has to take that into account in the initial refusal.
You're saying when we look at these other exclusions apart from 12.4a, first of all, they apply as the date of decision.
Yes.
But secondly, they apply as at the date of the decision to the documents held at that date.
Yes.
That's what you're saying.
Yes.
Whereas the other way of reading it is to say they apply as at the date of decision, but still to documents held at the date of request.
Yes.
Receipt.
I say that's wrong for the reasons I've
But it
given
may
right to go.
be in support of that second construction, you have to read these other provisions together with 12.4a, bearing in mind, which way did the Supreme Court go in Montague? They were in favour of aggregation, were they?
Aggregation permitted.
Yeah,
Yes.
so aggregation would include 12.4a.
It's a decision under FOIA specifically.
Yes, but one of the factors which would go into the balancing exercise could be 12.4a.
Well, yes, my lord. Aggregation under EIR is permitted by a different decision, by the Ofcott decision.
Sorry, okay.
But yes,
Yes, you're right, sorry.
I am working up to a submission that 12.4a should simply be disregarded,
Yeah,
discarded. So I don't want to defend it too much. But yes, if it has some value, it would be one of the factors that can be aggregated. And for that reason, I say it would be a nonsense for it to have its own.
This is a matter of language. As I said, your submission is that when we look at all these exclusions apart from 12.4a, you apply these exclusions, A, as of the date of the decision, B, to documents held as of the date of the decision.
Yes.
But there's nothing, is there, in the language which requires it to be interpreted in that way? It could be just as easily read as referring to documents held at the date when the request was received, couldn't it?
Well,
As a matter of language.
that was my submission on Regulation 5. The duty to which this is an exception is to make available information that you hold. And so I say when you are...
But if you're right about that, you say
Yes.
it then colours 12.
Yes, Mike.
Yeah.
Yes, it must do. It's also the only way to make sense of 12.4a. If we could set aside the directive for a moment and do what the Upper Tribunal did,
Yes, that's the final step.
yes, the only way to make sense of an exception for information that you hold now but didn't hold at the date of the request is for the holding requirement to apply as at the date of the decision, because otherwise, as my lord said, it would be a dead letter. It's not simply that the public interest balancing test doesn't make any sense, it's that there is no information to which you need to apply an exception, because it's out with the primary duty to which 12.4a is trying to set up an exception.
Well, that may or may not be so, depending on which exception you rely on in relation to what information. There may be information which you did hold at the date of the request, to which other exceptions apply.
But that still doesn't give any work for 12.4a to do.
No.
But it does do work in terms of communicating to the requestor as to why in certain instances they may have been provided with some information but not others. Otherwise, on your construction, the authority doesn't have to say anything because it doesn't have to record or reflect any exception because 12.4a in your world doesn't exist. Whereas in the world that it does exist, the person who's made the request, for which there may, as my lord indicates, be a variety of reasons why it's not being provided, will understand the categories of exception that have been applied to the request that they've been asked to consider. So it may mechanically not make sense to have it in there, but in terms of doing what the regulations and the directives seek to do, that is to say, have a well-informed public about what environmental information is available. If it isn't available, why it isn't available. 12.4a is purposeful, isn't it?
No, my lord, I say not on the appellant's construction, because the whole duty to make that information available doesn't apply in the first instance to information that only arises after the date of the request. There's simply no duty on them to say anything about it. So my lord's point that they could be silent about it would apply on the appellant's construction of the holding requirement. It would simply be out with their duty to make it available. Say no more.
Is that right?
Well,
I mean,
my lord,
I've already drawn attention to the use of the word refuse, which suggests that they've got a choice whether or not to disclose it. Why can an authority not say, well, we've got this information, but we didn't have it at the date of your request, and therefore we are refusing to disclose it pursuant to this request?
but it's
The
not under any-
requester can then make another request saying, well, now I know you've got this certificate or whatever it is, I'd like to see it, please. Because if you look at regulation 14.3, the refusal must specify the reasons not to disclose, including any exception relied on under regulation 12.4. So if you rely on regulation 12.4a, you've got to say so.
yes, my lord, but you don't have to rely on it, on the appellant's construction, because you're simply free of any duty in relation to that information. They say the only information on which the regulation 5 duty bites is the information that we hold at the date of the request. So if information arises after that date, this isn't,
But isn't,
I don't have duties in relation to it.
don't they have a duty to consider the request and also provide reasons for how they dealt with the request? Wouldn't those reasons include in, I mean, it seems to me in any event, all of your ambition in relation to this point about regulation 12.4a, maybe you having an ambition to prove too much, but doesn't it include a duty to provide reasons in response to the request, which would embrace whether or not they were under any duty at all? And that's what this is trying to capture.
No, my lord, I say the duty only applies to the information that's been requested.
The duty not just to provide the information, but also to deal with the request in a way which the regulations require. So the regulations require the person who has made require that the person who's made the request is provided with an answer to their request. Otherwise, they've got no means of getting on with regulation 11 at all.
But that answer could simply be, we don't hold this information.
Yeah, well,
As it is under
that's 12.4a, isn't it? That's them saying we're responding to your request by saying, actually, we don't have this information.
But
Which is the regulations providing what the directive wants, which is a well-informed public about what environmental information exists and to which they are entitled.
But if one compares what happens under FOIA, where the position is beyond any doubt as to what information is subject to the duty, what public authorities do is to say we don't hold this information. And that's not an application of any exception under FOIA. It's simply saying we don't hold information within the scope of your request. And the Commissioner deals with that on the balance of probabilities.
But this is a different regime to FOIA, as we know from the earlier authorities to which you've drawn our attention, and one which needs to be looked at on its merits in the context of the directive and the directive's objectives.
Indeed, my lord, but that's why it makes no sense for the holding requirement to be the same under EIR as it is under FOIA, because then one would be left with this dead letter of an exception.
That's a different question. That's an answer to a different question. The answer, the question we're looking at the moment is regulation 12.4a purposeful?
Oh. It makes no sense on its own terms, because the introduction to it is regulation 12.1, which says, subject to the following paragraphs, a public authority may refuse to disclose environmental information requested if an exception applies. So the regulation 12.1 exceptions are specific to the information that's been requested. And in order to make that meaningful, one needs the information requested to mean something to which 12.4a could apply.
Well, following that approach, would you mind if I asked you about Regulation 10?
Please, Mark.
Transfer of a request. 10.1, where a public authority that receives a request for EI does not hold the information requested, but believes that another authority does, then it's either to transfer the request to the other public authority or give the name and address, etc., etc. That strikes me as being a pretty simple provision, and you can only comply with the obligation to transfer in relation to a request as regards information presently not hold. It's not looking into the future, is it? You couldn't get out of Regulation 10 by saying, well, I may have it in the future. You either do or do not have it now in relation to the request.
Yes, I accept that, Lord.
Yeah, because then if you read on in 10.2, sorry, I beg your pardon. Life is never very simple. 10.2, yes, it is 10.2, where a request is transferred to a public authority for the purposes of the provision referred to in so paragraph 3, subparagraph 3, sorry, refers to our friend Reg 5.2 and another friend, I think, 14.2. So it's all tied in together. I mean, we're supposed to read these regulations as a whole, as a complete scheme. So that does seem to establish a link between holding and request, doesn't it? In present tense terms.
Well, what 10.2 and 3 are doing is resetting the clock for the second public authority.
Well, that's, yes, but it builds on 10.1, doesn't it?
Yes, but what you're not doing under 10.1 is applying an exception. You're transferring the request.
No, but are we not getting a clue as to what the draftsman means when he or she talks about holding information in relation to a request?
Forgive me, my lord. I don't follow the
It's the
linkage
point I
that you're
put to
making.
you. It's the point I put to you a few moments ago, which I thought you didn't find controversial, but there it is.
Well, I would suggest that 10.1 isn't concerned with specifying the particular time. It's simply a case of where the first public authority discovers that it doesn't have the information, and it's not a question of it arriving at a later date, which 12.4a wants to deal with. It's simply a case of it not having it, but believing that another public authority does. And that's what the exception under Article 4.1a of the directive is doing, in my submission, and not creating any exception related to new information. So 10.1 is doing the work of Article 4.1a of the directive, and 12.4a is, I say, an aberration that's creating exceptions not in the directive. I have now prefigured my submissions on 12.4a. I knew I would if I started talking about it.
It's irresistible.
Perhaps I could go on and come back to that, because I sense this is an issue that will continue to trouble us, my lords. I was on Regulation 12. I was observing that it's common ground that those exceptions, setting aside 12.4a, apply at the date of the refusal decision. So there are 20 working days in which circumstances can change in all sorts of ways. And Mr. Metcalfe accepted that a public authority would have to take account of those changes. I only observe that because it is said against me when we come to my reading of the Regulation 11 exercise, the second time around decision, that would place an impossible burden on the public authority to have to take account of changes in circumstances that arose during that period, that further period.
But is the key to 11 what we eventually decide is the meaning of has failed to comply?
Yes, and we're coming to regulation.
In relation to the, I mean, we have to read it as a whole, but that's a key component of your argument.
Yes. And I'm coming to that now, my lord. So we now postulate the scenario in which a request has been refused in part or in full, and the requester makes reconsideration representations under Regulation 11, and that they are representations about that refusal and not representations about something else like the form and format of the information.
So what the requester does is to make representations, not a new request, in relation to the applicant's request. And that's the request that was originally given under Regulation 5.
Mm-hmm.
So we're back to the date on which that request was given. What the requester is doing is not making a fresh request, but making representations about how that request was dealt with.
Yes.
Is that right?
Yes.
Yeah.
So now, of course, I accept that the applicant can only be complaining about a failure that's embodied in the original refusal notice. And that, I think, was my lord's point.
Yeah.
They only know about the refusal that they've got.
And I think the facts of this case illustrate, I don't know if you think it's right, that this procedure can be used where there's been no decision at all. The failure could be a failure to give a decision, for example, within the time limits.
Yes.
And the Information Commissioner criticised, I think, the HSE on that basis.
Yes.
Yes.
But although the applicant's complaint is about a failure in the refusal notice, that does not mean, in my submission, that the public authority's duty, when it receives those representations, is limited to a review of whether the original decision was correct on its own terms. Because the representations that it receives and which it must consider under Regulation 11.3a could say, well, things have changed since the date of that refusal, and your original refusal is no longer valid. That is a perfectly valid form of representation that an applicant could make.
So the representative could say the situation has changed.
Yes.
So that the original decision is no longer valid. By implication, it was previously valid.
Yes.
This sounds like a new request.
Well, it's a streamlined procedure by which you can achieve the same thing.
But our starting point is the applicant saying, when you dealt with my request of the 1st of January, and you gave me an answer on the 20th of January, you didn't comply with the requirements, one way or another. The question then for the public authority receiving those representations, surely, is to decide whether that complaint is valid, to decide whether, if it has complied with the requirements. That's the question.
My lord, that's not quite what 11.1 says. If it appears to the applicant the authority has failed to comply.
Yes. So we
Not
agreed,
that
I
it-
think.
that it did fail to
We
comply.
agreed, I think, 5 minutes ago, that that is a complaint about how the original request was handled.
That is a complaint about the refusal that's embodied in that decision notice.
Yes.
But it is conceptually possible for an applicant to be saying, although that was right at the time, you have now not complied because circumstances have changed.
Well,
So imagine a refusal for a fair trial. And as between the relevant dates, the trial comes to an end and the defendant's found guilty. The applicant could say, you are now not in compliance with that requirement because of that change in circumstances.
You have previously complied with it, but now circumstances have changed, you no longer comply with it.
Yes, you have now not complied with it.
But going back to my lord's question, all this asks is whether you have failed to comply. So if you imagine the situation you just postulated, the answer to the question would be yes, you have failed to comply, which are now no longer comply. I mean,
Well, when the public authority comes to decide under 11.3, if it has complied with the request, again, my submission is that the sense of the present perfect tense there and the particular choice of the present perfect, as opposed to the aorist, is that the compliance is something continuing.
Why?
Because that's
I don't really understand that.
that's
I mean,
what present
in
perfect
your
means.
broken arm example, you've
Yes.
only broken your arm once. It may have continuing consequences, but there's only one event,
Yes,
one
but-
break.
But consider the disclosure. I mean, the broken arm is an example that illustrates the general tendency of what
Yes.
the present perfect is doing.
Well,
But
I entirely agree with that. If you say that people have been married for 30 years, you generally imply they're still married.
Yes, yes, my lord. And it depends on what the underlying condition that one is considering,
Right.
the nature of that condition,
But
as to
here,
whether it has that continuing consequence.
but here I thought we had agreed that the condition that we're talking about is the original refusal.
My lord, to the extent that I agreed with that, I only agree with it to the extent that
See,
it must be set out in the original refusal because that's the only information the applicant has, but they are entitled to say you are now not in compliance by reason of a change of events.
Doesn't there need to be care in relation to what evidence and information that the applicant presents as part of their review process, whether it bears upon the circumstances, which is new information about the circumstances pertaining at the date of the decision, or whether it's new circumstances which mean a different decision should be taken in principle. So that there are a number of exceptions to it, exceptions leaving aside 12.4a, to which that might pertain. But there is a question, isn't there, about the nature of the new information and whether it bears upon what was known or understood at the time of the original decision, or whether it's actually a whole new decision that needs to be reached.
Well, my lord, I say it's not at this stage confined to information that bears on facts and matters that they stood at the original time. That has to be the case for the next stages, the review stages, by the Commissioner and the FTT, and that's what we're told in Evans.
Yeah.
But that doesn't apply, in my submission, at the stage of reconsideration internally. And stepping back, we should ask ourselves, why should the public authority be entitled to dig its heels in on an exemption that all parties agree no longer applies? Why would you not provide the requester with a simple procedure, which will only arise in particular circumstances, of saying things have changed, you can now disclose this? That would facilitate access to the information much more simply than having to go through the loop of putting in a further request, which, let's not forget, gives rise to different rights of complaint to the Commissioner and separate appeal rights to the First-tier Tribunal. Because each of those following stages attach to a request. A complaint has to be about a particular request, gives rise to a decision notice, and appeal has to be about a particular decision notice. So if we are saying, as has been said several times in this court, well, why not just make a fresh request? The court needs to appreciate that that is multiplying the procedural complexity for the requester, for the Commissioner, and ultimately for the tribunal system. If you end up with two separate refusals, rather than simply a two-stage decision by the initial decision maker.
can I just make sure I've understood the way you're putting it? Because you're talking about a situation which has changed since an earlier decision. which in your question is accepted as having been valid, but is now no longer valid because of a change in circumstance. Change in circumstance could be something which goes into the public interest bounds
Yes.
without new environmental information having become available.
Potentially, not necessarily.
But at least your submission embraces that.
Yes, my lord.
But are you going further and to say there is a need to reconsider because the situation has changed in that there is new environmental information?
Yes. Yes, because all of my submissions on the holding requirement being in the present tense, as to the first refusal decision, I say apply equally to the second decision.
So again, we have a situation where a member of the public says, I want to rely on Regulation 11. Here are my new representations. There is a change of circumstance, and that includes new environmental information which you have got.
Yes.
And then the local authority has to go through the decision-making process.
Yes.
Under Regulation 11.
Yes.
The alternative is one could simply request the environmental information
Yes.
as a fresh request. And for the life of me, I'm trying to see why it's advantageous to proceed under Regulation 11 rather than making a fresh request.
Well, these matters often arise. For clarity, we are focusing on this being the sole issue in a request, but it might be one element of a 5-part request, and you might have the applicant might have concerns about how parts 1 to 4 are addressed that don't engage the issues that we've been talking about.
Mm.
And if you are now saying that they have to make a separate request simply in relation to part 5, because that's how the holding requirement works, and the answer to that part 5, that request, sorry, that repeated request in relation to part 5 come back and it's unsatisfactory, then that applicant now has 2 procedures running. It'll have to make 2 complaints to the Information Commissioner, who will have to issue 2 decision notices, and there have to be 2 appeals to the First-tier Tribunal, potentially combined, but there is certainly additional complexity, and in my submission delay, much has been made about the need for timely access to information. But why reset the process when it can simply be done on reconsideration? Bearing in mind that a fresh request also brings with it a fresh right of reconsideration.
Is there any burden on anybody to identify new material?
Yes, on my construction, because the duty on the public authority is to make available the information it holds.
So when the public authority receives representations under Regulation 11, it's got to look through its records and see what, if any, additional information there is relating to the topic on which information has been requested.
Yes.
And if it had originally looked for information before making the initial decision, it might have been able to make a charge for doing that under Regulation 8, right? But under Regulation 11.3, it's got to do all this free of charge.
Just have a moment, I haven't considered the differential application of the charging provisions. No, because charging is allowed where a public authority makes environmental information available in accordance with Regulation 5.1, which is what it would be doing at a second attempt on reconsideration.
Well, what is 11.3 doing then?
prohibit it from charging for that process.
But that would include, why would that not include searching through the archives to see if there's anything more? You say that's what they've got to do, as presumably as part of the decision, whether it's complied with the requirement, and it looks on the face of it to be something they have to do free of charge.
Well, look, I confess I'm thinking about this for the first time, but I think the answer is that the free of charge applies only to the requirement under 11.3 and doesn't in terms apply to what the public authority then has to do under 11.5, which is the making available. And therefore it's a liberty to charge for that second step.
But except, I think if I may say so, it's relatively straightforward. 3, 4 and 5 tie together. So 3 starts off by saying you've got to do this free of charge. What have you got to do? Well, it includes the notification in subparagraph 4. And then 5 says the notification under subparagraph 4 includes a statement of what you're going to do to remedy the non-compliance.
Yeah, it may be that a public authority would be in a tight spot charging for disclosure under reconsideration. But if it's unduly onerous, it can apply the manifestly unreasonable exemption. Because, of course, on my construction, it's entitled to apply that as at the date it's taking this later decision. And that is the protection that it has against all of the asserted burdens that my learned friends raise. But if this all becomes too difficult on a particular set of circumstances, then it can always apply the manifestly unreasonable.
Is to ask oneself the question, why is Parliament put in, because I'm not sure this comes from the directive, but be that as it may, why is it put into subparagraph 3 a requirement that it be free? That might be a clue as to what is the scope of 11.1. And it's meant to be dealing with additional representations about a request you've already made, where there may have been charging already, perhaps. As opposed to something which could, on your reading, be dealt with under 11, or alternatively, could be dealt with as a fresh request.
Well, what I would say about the free of charge provision is that it's a further pointer that my construction favours the requester, which I say is in accordance with the purposes of the directive. So, as I say, all of that submission about the effect of Regulation 11 relies on my submission about the present perfect and its effect. And you have my submissions about the broken arm, you have my submissions about disclosure.
Yes.
I just wanted to explore that disclosure example slightly more, because the nature of the underlying requirement is what gives it that continuing effect. So disclosure is an ongoing obligation. And it can be correct to say we complied with our obligation, but incorrect to say we have complied with our obligation if circumstances change. To take an example slightly closer to home, the certificate that you see at the front of the authorities bundle that we have complied with the requirements of PD 52C was correct until we went and inserted the non-reported version of the Burkitt decision. So with apologies to the court, we have actually come into non-compliance as a result of that, and our certification of compliance is no longer correct. So you see the way in which the present perfect tense gives rise to a continuing obligation where the underlying obligation is...
I don't think that's a very good example, if I may say so. You know, the certificate was always incorrect, because Burkitt had been reported.
But we didn't have Burkitt in the original bundle
No, quite.
when we wrote that certificate. So that certificate was correct with the unamended authorities bundle. And then when the supplementary skeleton arguments went in, and someone wanted to rely on Burkitt, it was added to the authorities bundle which you have before you, and no one updated the certificate.
Right. So it was correct when it was given.
Yes, but the statement that we have complied in relation to each of the authorities in this bundle.
Well, that depends on how you read the statement we have complied. It's the certificate's given on a particular date. And so you're saying we complied with our obligation on that date.
I'm not saying we complied, I'm saying we have complied with our obligation in relation to each of the authorities, is what the certificate says. And it is I'm afraid, no longer correct. Now that circumstances have changed and an unreported authority, an authority in unreported form has been added to the bundle.
Yes.
So, my lords, that's the critical difference between Mr. Metcalfe and me in relation to ground one. And broadly, I accept what Mr. Metcalfe says about the effect of Montague. It is necessary but not sufficient that there is a difference between EIR, but the difference between EIR and FOIA is that reconsideration is mandatory. That's what the fact that it's mandatory under EIR gets me into the territory of considering what the nature of the reconsideration exercise involves, because it's a mandatory part of complying with the requirements. But I accept that it's not a sufficient condition, because I do have to show that what the public authority is doing is more than simply reviewing the original decision as matters stood at the original date. So I don't propose to take you back through Montague, because effectively I agree with Mr. Metcalfe about that. I just want to address a couple of other points that I say support my interpretation on the nature of the Regulation 11 exercise, and address some of the counter-arguments. Because as you'll be aware, I draw support, and it's no more than support, from my reading of Regulation 11, from the description of that exercise as reconsideration as opposed to review. Except that term's not definitive, but in my submission it does point towards a fresh consideration, and that in turn points towards considering matters as at the date of reconsideration, the later date. That term's used in the heading of Regulation 11, accepting of course that a heading is not amendable as the statute goes through Parliament and so carries less weight. But it's also, and especially is used in the underlying Directive Article 6, which you have at page 12 of the authorities bundle.
In fact, I think it's right to say that none of the regulations are capable of amendment in Parliament. If it's a statutory instrument, Parliament either accepts or rejects it, doesn't amend it. Isn't that right?
If it's subject to the affirmative resolution
Well,
procedure.
it could be affirmative resolution, or it may require a negative resolution, but you can't amend regulations in Parliament.
My lord, I would have to double check whether that's correct.
It's not uncommon for another statutory instrument to be passed, which would include alterations to existing statutory instruments. For instance, rules in tribunals and courts are regularly, I was going to say tinkered with, but they're regularly, purposefully improved by that process.
I'm on slightly unsure ground now, but is there not a parliamentary scrutiny committee that considers the effect of a certain class of statutory instruments and can recommend? I don't want to make a positive submission on that moment. I'm not sure.
Reference has just been made to the fact that these regulations were passed by affirmative resolution.
Again, I don't know that that's the case.
That seems to, if one goes to the King's Printer copy, that's what seems, it says, whereas a draft has been approved by a resolution of each House of Parliament. I take that to be affirmative resolution rather than just simply laid before Parliament and subject to the negative resolution.
Yes. But whether that resolution had the possibility of amending.
Well, that's a separate question.
It's a separate question.
I myself had thought that I'd come across amendments being tabled, but I may be wrong. But quite apart from that, the affirmative resolution was required because this was Section 2 of the 1972 Act.
Yes.
Which would have meant there would have been a debate in Parliament and the regulations would have been introduced by a minister. Has anyone checked to see whether there's, I hesitate to ask this, whether there's any relevant admissible pepper and heart material?
I have not checked.
I mean, there may not be much on the basis this was just copy out or transposition. But
well, it's quite far from directly transposing
the
directive.
Well, what I've been looking at looks as if it's copying out but rearranging. But anyway, that you don't know the answer to that.
I don't know.
Thank you. If anyone else does.
Well, as I was inviting you to look at Article 6. Article 6.
You're going to come back to 12.4a at once.
Yes, right at the
Yeah,
end.
I'm sorry, I beg your pardon.
Article 6.
Article 6.
And you made the point that reconsideration is a word used there.
Yes. Not only that, it's used in, I say, meaningful contradistinction to review, which is what the Commissioner carries out, and then subsequently the Tribunal. The administrative and legal review procedure is, in my submission, meaningfully different from the reconsideration decision, whether that's taken by the public authority or another public authority. It would in either instance be reconsideration.
Would you, I mean, this is an article which gives a choice to member states about how they deal with the response following a refusal or inadequately answered. And as I think we agreed before lunch, there are three options. You can have a reconsideration by the original authority, you can have a reconsideration by a different authority, or you can have an administrative review by, in our jurisdiction, the Information Commissioner. Would you not expect, in the case of an EU-wide directive, that the questions to be answered by whatever method you choose would be the same, irrespective of which method you choose?
Well, not necessarily, because the directive has given quite a lot of freedom here to the member states to select which procedure or combinations of procedures they wish to implement. And it seems that the directive considers the reconsideration stage to be optional because it's an either or. But what it also appears to indicate is that where you are carrying out a reconsideration, I would say typically by the public authority concerned, the nature of that exercise is going to be different. The nature of that exercise will be different, my lord, because the ball is still within the court of the public authority that took the first decision. And that's why the directive chooses to describe that exercise as reconsideration.
So the public's substantive right to obtain environmental information could vary according to which mode is chosen by a member state.
That's a necessary implication, yes, of the Freedom Directive. But as I understand it, given the multiplicity of legal systems in the EU, it's quite common for questions of that nature to do with how endorsements and appeals are pursued, that there would be a relatively high degree of freedom.
There appears to be something, may or may not bear upon this in Article 2, where it talks about what the definition of public authority may be, and makes specific provision for alternative constitutional arrangements in different member states as to. I was just looking to see whether there was indeed anything in the definitions part of the directive which might bear upon this question. And it does appear that the necessary flexibility to accommodate a whole diverse range of constitutional arrangements is reflected in this.
In the text, one sees after 2C.
Yes.
Yeah.
Yes.
I agree.
Yeah.
Just at the end of Article 2.2, they exclude, member states can exclude judicial and legislative bodies if their constitutional provisions of the date of adoption of this directive make no provision for a review procedure within the meaning of Article 6, then member states can exclude them. Review, not reconsideration.
When referring to the bodies acting in a judicial or legislative capacity. First sentence.
I'm not sure it reads that way still.
It's quite opaque, that particular paragraph, which
Yeah.
is why I raised it, because I wasn't quite sure that I really understood how it was practically meant
Yes,
to be applied.
I'm not sure I'm going to be able to shine much more light on it or through it if it's opaque.
May simply be a reflection in the way in which the directive was prepared of the very, very diverse range of judicial and administrative traditions that there are embraced within the jurisdictions that it covers.
It has the feeling of something that one member state has
Yeah.
asked to be included.
Well, see, some public bodies may not have a power of either reconsideration or review in a continental jurisdiction because any questioning of any decision they reach involves the whole file being passed to some other body that then makes a decision about it. So it's very difficult to work out whether or not there is in fact in the directive any definitive distinction to be drawn between review and reconsideration in terms of either process or indeed the substance of what's entailed in either review or reconsideration. That's what puzzles me in relation to this.
I mean, I wonder if the answer is that the first sentence allows for the exclusion of judicial bodies from the definition of public authority, but where that is not done, the second sentence. So if you have a court or tribunal, quasi-court or tribunal, acting as the public authority which is subject to the original duties, then...
Which you may do in some jurisdictions where a public body makes a decision and then that's it, they're functus, effectively.
And
whole
the code
file
says that
gets
they're
shipped
functus.
off to
Yes.
some court, which then would not necessarily comply with having either a reconsideration or a review, because they're making,
Yes.
they're the legal body who are dealing with the decision pursuant to the directive.
Yes, but it's an odd provision where the reconsideration isn't mandatory in the first place. So I'm not sure where that leaves us, my lord.
Well, it certainly leaves me still puzzling about whether there is truly any distinction to be made between the language of review or reconsideration. But in fact, they're a kind of fungible concept which depends upon the administrative and constitutional and judicial arrangements of the state in which you're trying to deal with the directive. That may or may not affect your submission, because we're looking at it in the context of the UK's transposition of these provisions.
Yes, well, I think what I'd say is, firstly, that in the paradigm case, where you don't have the complication that we're looking at here in relation to judicial bodies, the directive does make that distinction. It perhaps gets a little bit blurry when one has to deal with the more difficult cases of judicial bodies treated as public authorities. the second point I would make is the one my Lord has just made, that my submission on Regulation 11 is based on and doesn't require anything from the it's based on the EIR and doesn't require anything from the directive. It simply draws some additional support for what it's worth from the term reconsideration.
Right. Now, where do we go from here?
We go to Burkitt, my Lord, because it said against me that Lord Justice Sullivan didn't maintain the distinction between the reconsideration and review terms. I think I can take that very quickly, given my Lord's indication to Mr. Metcalfe that Burkitt is simply deciding a different issue, and that's what I would have said in my submissions to the court. It is the question of law is stated in paragraph 1. Can a public authority rely on new exemptions at the stage of administrative or legal review? So what's contemplated in Burkitt isn't that the circumstances have changed, but that the public authority's got something wrong and wants to go back and correct it. In that context, my Lord, it's natural that it should talk about correcting the earlier decision, and that simply doesn't impinge on this case. So in light of the time, I won't go any further with Burkitt. I do want to deal with Evans, though, because it's said that Evans is authority for the relevant date being that of the initial refusal. My Lord, you have the answer to this point of my skeleton argument, which is that at the stage the debate authorities had reached, Evans was concerned with the wider question of whether the relevant date for the Information Commissioner and the Tribunal is the time when the public authority is handling the request, and I say that broadly, or whether it's when those later bodies are considering their decisions. And so it's not concerned with drilling down into the time when the public authority is holding the baton, if I can put it like that. It's simply concerned with whether the relevant time is when the public authority has the baton, or when the Commissioner has, or when the Tribunal has. So it's a broader question. And what one sees is that the Upper Tribunal in Evans had identified the latest date as being the date of the internal review. If we turn up paragraph 39 of Evans, at page 141, page 141, Lord, and paragraph 39. So Lord Neuberger records that the Upper Tribunal in that case considered the date at which the position must be tested cannot be later than 28th of February, which was the latest date by which any of the departments ought to have concluded their internal review of the decision. So it's an ought to have concluded rather than did conclude, but it encompasses the internal review. And when Lord Neuberger comes to set out his view, he doesn't correct that, paragraph 72 to 73. He simply talks about the date of the original refusal. And in my submission, what he's doing there is talking about original refusal as a composite concept, because he's concerned with deciding that broader question. If he'd been concerned with subdividing the time when the authority has the baton, then he would have made it clear that he disagreed with the Upper Tribunal. And the Upper Tribunal in Montague spotted precisely this issue, picking that up at tab 10 of the authorities bundle and going straight to page 273. Beside B in the margin, the case law we refer to below, such as Evans and Apgar, address a debate about whether the correct date for assessing the public interest balance is the date of the public authority's refusal decision, perhaps including the date of any internal review of the decision, or is the date of the FTT's hearing, and so forth. And at 55, which Mr. Metcalfe took you to, he's just cited paragraph 72 to 73 of Evans, and then says, sorry, the Upper Tribunal has just cited, and then they say this conclusion on public interest timing was made in a context where, per paragraph 39 of Evans, which we just looked at, the refusal decision may have been assumed to include the period up to when the public authority ought to have concluded its internal review. The decision to refuse. And what's more, the three-judge panel of the Upper Tribunal in APCA, which came after Evans, read Evans as including the internal review. We see that in the quotation from APCA, which is embedded at paragraph 56 of Montague.
56
of Montague. It's APCA 44 cited at 56 of Montague. The question is still a broad one, assessed by reference to the circumstances at or around the time when the request was considered. So it simply doesn't have the precision that we're dealing with at present.
Well, the provisional view which the Upper Tribunal set out in 58 subparagraph 1 was the date the public authority makes its decision on the request,
Yes.
but does not include any later decision. And I
Yes.
think that is the view they ultimately adopt, isn't it? Not least because there is no requirement for a review under FOIA.
Yes, my lord. But the purpose of showing you what was decided in Evans and APCA is by way of saying that was still an open question by the time the Upper Tribunal had to decide it in Montague. Otherwise, there would have been no need to discuss it. It would have been decided by Evans. And they wouldn't have had to hear long submissions from myself and Mr. Metcalfe about why it should include the date of the internal review. And so that's all spelled out at 57 of Montague. Not disputed in APCA that the date of the public authority's decision would include any tenuous review of the decision by the authority. And that's why the Upper Tribunal goes on to decide the point as if it's free from authority. And all it does is come back occasionally to Evans and draw some comfort from the conclusion it's independently reaching based on the reading of the FOIA provisions. And that brings me, so that I said there's no contrary authority on this point under EIR. Evans isn't authority on that and wasn't examining the question. The other point that I draw from this exercise, and this brings me on to the practicalities questions, is that until the Montague decision, what the appellant in this case is now saying about EIR was regarded as the prevailing orthodoxy under FOIA. That's how it was described in the APCA case, that it would include the internal review. And APCA was a case where the public authority was a central government department, Foreign and Commonwealth Office, and counsel for all parties agreed that that was the correct position. And in Montague itself, as I've just said, the Department for Business and Trade, represented by Mr. Metcalfe, and the Commissioner, represented by myself, were arguing for that orthodoxy to be maintained. And that was the view of the regulator and public authorities up to 2022, in my submission should give you pause when you are considering what are said to be the serious negative consequences of that interpretation. Because those serious consequences were not apparent either to central government or to the Commissioner after 15 years of operation of the Freedom of Information Act. And what's more, this appeal raises a point of statutory construction, and that the policy or the practical arguments in my submission will only ever be of secondary importance, and that they can't displace an interpretation based on the statutory language and context, because as so often they can cut both ways. And that is why I say they should be given relatively little weight.
Yeah.
It's not a point, contrary to Mr. Metcalfe's supplementary skeleton argument about the expertise of the Commissioner, It's simply about their status in the hierarchy of interpretative tools. As to the specific objections to the construction that I'm advancing, the HSE's primary objection is that you might have to decide quickly on the status of a new document if it arose late in the period for consideration. That's the primary point that Mr. Tabori relies on. The specific context which he raises for HSE is where you have a live investigation. Now, it seems to me that in a context like that, then Regulation 12.4d could quite readily be applied. And what's more, in any case where these issues did give rise to any serious burden, or any undue burden on the public authority, then it would have the right to rely on the manifestly unreasonable exemption. On all the parties' case, that applies at the date of the initial refusal. So if a document arises during the first consideration and it suddenly makes the request extremely burdensome, then on all of our interpretations the first time around, the public authority is entitled to say, well, hang on, now that I have to deal with this additional document, this request is too burdensome for me to respond to, although they would, of course, be expected to apply the Regulation 9 advice and assistance provisions before doing that. And the most obvious way to do that would be to say to the applicant, well, look, I need to time limit this request if I'm to respond to it within a reasonable burden. So the short point is that there are guardrails to protect public authority against the sorts of negative consequences that are raised against me, even if those issues would cause genuine problems. The Commissioner raises two further separate points. Paragraph 34(2) of the replacement skeleton argument suggests that a public authority could game Regulation 11 if it meant what I say it meant by simply delaying its response. But in my submission, when you are assessing how a statutory scheme ought to work, how it's intended to work, you can't rely on the possibility that a public authority would cynically disregard its obligations under that scheme, because where does that lead you? You could equally say public authority could game the system simply by concealing the information. So you can't rely on a counterfactual in which a villainous public authority simply disregards its duties. You need to assume that the rules are going to be followed. And then the Commissioner also raises the spectre of mixed cases of environmental and non-environmental information, which would then have to be dealt with on parallel tracks, partly under EIR and partly under FOI. Now, I accept that does add some additional complexity, but in my submission, that's simply not a reason to read the legislation any differently. And just to note what's said by the FTT in the case of Vermter, Vermter, it's in the bundle, my lord. I don't suggest you turn it up, just for your note. It's asserted at paragraph 123 on page 342 of that decision that there are good reasons for the same date to apply in both regimes, including that it's legitimate for a public authority and a Commissioner of the Tribunal to consider a request on an either-or basis. That's either FOIA or EIR. Now, in my submission, that's just wrong. It's putting the cart before the horse. It may be legitimate and proportionate to park the question of whether it's FOIA or EIR if it makes no difference, but you can't reason backwards from that and say that the dates should be the same, but it should make no difference, just so that we don't have to carry out the task of deciding which regime applies. So in my submission, there are no sound objections of unworkability that would cause you to depart from the interpretation that I'm pressing upon you. And that brings me back to Regulation 12.4a, my lords. Now, the Upper Tribunal read this purely domestically, and its reading on that basis, in my submission, makes perfect sense. If we could park the directive and simply read the provisions that we have in the EIR, then it would give support to my reading of the held requirement, because it would give work to 12.4a to do, which it would otherwise lack. Because the requirement.
For the sake of avoidance of doubt, can you just spell out exactly what you're saying?
So, my lord, let's turn up Regulation 12.
I think if I've understood it, your point goes like this. An authority holds information, no matter when that information comes into its possession, and it's relevant that it holds information at the time of any Regulation 11 review or indeed an original decision. And it is only because 12.4a says it can refuse to disclose information which it didn't hold at the date of the request, which supports a broader interpretation of holds than might otherwise be the case.
Well, I disagree with the might otherwise be the case, because I say I get there on an actual
Yes.
reading of the regulations.
That I understand.
But I say that if my reading is wrong, then 12.4a is not doing anything, because the obligation on the public authority, the primary obligation, is simply to disclose the information that it holds within the scope of the request. On my reading, that includes information of the kind that's described in 12.4a, information that isn't held at the date of the request, but is held at the date of the consideration of whether to disclose.
But it is doing something, isn't it? Because it's saying that although the obligation to disclose applies to information that you hold, you may choose to object to provide it on that ground. You may choose not to. You may, for example, say, well, I've actually come into possession of this information subsequently. I don't have to provide it, but I will. Alternatively, you can say, I'm going to maintain the position that I shouldn't have to disclose it, relying on 12.4a, because I didn't have it at the relevant time.
Well, you would only be under a duty to which you would need an exception if my construction of the holding requirement applied. Because on the appellant's case, you simply have no duty which attaches to any information that isn't held at the date of the request. It's completely outside the scope of the regulations. And Regulation 12.1, the introductory text, says a public authority may refuse to disclose environmental information requested if an exception to disclosure applies. We don't even get to that stage on the appellant's reading.
Yeah, but maybe.
Environmental information requested doesn't encompass the information that's described in 12.4a.
This is where the regulations do follow the directive. And maybe the way to read them together is that there is a duty to disclose unless you take a point under 12.4a.
But how can one reconcile that duty with a reading of Regulation 5 that says there's no duty if you don't hold it at the date of the request?
Sorry,
You
that's
don't
what I was.
need- You don't need to, because under Regulation 14, there is a requirement to provide reasons why you have refused to disclose, which embraces all of the potential exceptions under Regulation 12.4 and enables the recipient of the refusal to understand that one of those reasons was that there was no information which was held pursuant to Regulation 5. So it's there's a freestanding purpose beyond the one to which you cleave, namely, well, there is no duty, etc., etc. So it breaks back to the point I was trying to make earlier, which is the purpose of the purpose of the directive. It is also to enable people to understand, for instance, why they haven't received environmental information, and that's why Regulation 12 and 14 read together facilitates that understanding.
But my lord, regulation 14 applies in the terms of 14.1 if a request for environmental information is refused under regulation 12.1. So regulation 12.1 would need to bite
Yeah,
before you were making a refusal.
and it would do because there would be an exception under regulation 12.4a. So they all it all reads together for the purpose not of disclosing environmental information, but for the purpose of enabling a member of the public to understand also why they might not have had access to the information that they had requested.
But I feel like we're perhaps going around in circles now.
Well,
But
yeah.
I say that regulation 12.1 cannot kick in if there is no requested information on which it can bite, which would be the case on the appellant's construction of.
That's predicated on the basis that as I said earlier, that you need to prove too much. You don't. That you can read them both together as providing, as I said, for the ancillary purpose of enabling somebody who's gone to the trouble of making a request as to why there might be a category or all of their information that they don't receive. Otherwise, all the public authority would do is simply not deal with it.
But my submission is entitled to not deal with it.
Well, they may
Because-
be, but the poor person who's made the request is left in the dark as to why they've had the sound of one hand clapping from the public authority.
But
Whereas the regulations appear to have as a part of their purpose to include the information being provided where a request has been refused because the information is not held.
but then they're not in my submission placing any enforceable duty on a public authority to do that, because the regulation 14 obligations only kick in if a request for environmental information is refused under regulation 12.1. And I think what my lord is positing is a sort of is something outside the regulations, which I accept would assist the requester, but it isn't something that's provided for by the scheme. And I say partly for that reason, the scheme is misconstrued, and I come back to that because regulation 12.4a is providing for an exception that isn't in the directive. But this is the second submission that I haven't yet made on 12.4a, which is that it's instituting an exception which isn't in the directive and which it cannot do, because it purports to be implementing Article 4.1a, but Article 4.1a doesn't tell you anything about the time of holding. Article 4.1a is a provision all about which public authority holds.
Now, I think, Mr. Lockley, I'm going to have to ask you to finish by 4 o'clock so that Mr. Tabori and Mr.
course.
Metcalfe have an opportunity to reply.
I mean, this is my final point.
Right.
I don't know how much more. I mean, we've discussed it at some length.
Now, this is a directive that is being transposed.
Yes.
So a Marleasing interpretation would apply,
Yes.
but there's no question of disapplying 12.4a as there would be if this was a European regulation. Is that right?
No, I say you can disapply it
Can disapply it.
because
Under what?
you're required to read the regulations conformably with the directive.
If you can.
Yes.
But if you can't, there might be a Frankovich
As
claim against the state.
Not for secondary legislation.
Is that right?
I think there's some recent case law in this in the last 3 or 4 years. But this point hasn't been taken in the skeleton, has it?
It has been.
That we should treat the regulation as disapplied.
Yes, that's in my supplementary skeleton argument. But, and I deal with the Brexit point because the supremacy of EU law
Well, what,
wouldn't now apply, but this is sufficiently old that it relates to something.
shown any authority on this.
what you say in paragraphs 38 and 39, the conclusion 39, is that we're asked to read down the words at the date of the request. You don't specifically say we can disapply them if they cannot be read down.
Yes.
But is that your submission, that we can and should, if we come to the view that 12.4a is clear and that no amount of Marleasing interpretation would make it conform with the way you say the directive works, the only escape route is that we refuse to apply 12.4a.
Yes.
And is that what you are asking us to do in the event that we decide that the words are simply too clear to bend to a Marleasing
Yes.
interpretation?
Yep.
And you say that we have the power to do that. It's not just a Frankovich claim. We have the power to do that because this is secondary legislation.
Yes.
Right. And the authority for that is?
I don't have that at my fingertips.
Yes.
But in fact, my lord, the public authority hasn't applied that exception. So there is in fact no need to wade into that territory.
There is no need.
I think there is no need to wade into that territory because
Right.
that's not yet been applied to refuse the information. That was a suggestion of the Upper Tribunal.
Right.
My lords, unless I can assist you further on that.
Can we just be clear about why you say 12.4a is not consistent with it's Article 4.1, correct?
Article 4.1a of the directive, my lord.
Again, it may go back to how one reads Regulation 5. And the question as to whether there's a link between holding and request. It may depend on whether that is to be understood as referring to information held at the time when the request is made, not information which comes into the possession subsequently.
Yes.
It's the same discussion again, isn't it?
Yes, you would need to be with me on the holding requirement in order to find
It's the same
the
point.
non-conformity, yes.
Thank you.
But you can't read the directive in the light of the regulations.
Of course not.
Because there has to have an autonomous meaning and a consistent application. But
No, but linguistically, here we're having trouble to look at other languages, but linguistically it's the same sort of
it's the same issue.
interpretational point.
Yes.
Yeah.
The public and I say 4.1a is concerned with the which public authority question, and that's all the words to which the request is addressed is doing. It isn't, contrary to what Mr. Tabori says, giving any indication that the holding requirement is time limited to when the request is received. A request remains addressed to someone until it's transferred to someone else. And so I say the holds requirement, the present tense requirement of holding, about which I've made my submissions, whether it's under Article 3
But
or
if you-
Regulation
if
5,
you
is not
say
displaced
about
by
which
Article 6.
local authority holds the information, assuming the information exists. It's a bit like the Regulation 10 question that I put to you, and the transfer from one authority to another. Again, it begs the question, who is holding the information at the time of the request?
Well, I disagree that it imports the question of the time of the indication of the time of the request.
Well, I'm finding it very difficult to understand how you can answer the question, who holds the information, without knowing the time at which you're posing the question.
Therefore you fall back on the general timing point under Article 3, which is the time that you're making any decision under the regulations. So it's the time you come to decide whether you should transfer it or not the date of the request. My lords, unless I can assist you further.
Thank you very much. Mr. Tabori, do you wish to reply?
Very much so, my lord, but I think my other friend, Mr. Metcalfe, was going to.
I'm happy for Mr. Tabori to reply first.
Normally we go in reverse order, but I
Perfect.
do it the other way, that's fine, I don't mind.
In your hands, but I'm happy to start. Working through in the order the points were made. The introductory points made by my friend in terms of the recitals and the aims of the directive and so on, don't take your lordship's task any further. We of course, I think across all three parties appreciate the purposes of the directive and behind it are us. But the point is it's given effect through a qualified right of access and through the dissemination right. It's the particular principles don't really assist with the quite narrow point before you. We say that in relation to the point about section 1.4 of FOIA having a more express provision saying that it only relates to information held by the public authority at the date of the request, we say the same meaning is to be found in regulation 5.1. As to the point about holds being in the present tense, and so can be continue to be in the present tense effectively as at the date of the decision, or even a subsequent decision, namely the internal review reconsideration decision, that is flawed in that it overlooks the accompanying word request, which is the word that pins a particular time to what is held. Otherwise, it becomes much like the and duplicative of the regulation for the progressive dissemination provision, which is a rolling duty rather than one time specific. Regarding regulation 5.4, on which reliance was placed, which states, for the purposes of paragraph 1, where the information made available is compiled by or on behalf of the public authority, it shall be up to date, stress my learned friend, accurate and comparable, so far as the public authority reasonably believes. It is subservient to regulation 5.1, as it says on the outset of 5.4.
In other words, up to which date?
The date of the with which 5.1 is concerned, namely the request, rather than a month prior to that date. That wouldn't be complying with 5.4. We accept what my learned friend says about the fact that if we are right on 5.1 as to the scope of the request set by the link between holds, it, and requests, that you effectively don't need regulation 12.4a. We accept that. It doesn't make it otiose or redundant because its effect is not cancelled out. It's simply duplicative and effectively buttressing the earlier provision. As to the point about which my lords were asking my learned friend regarding what would the difference effectively be between a reconsideration request and an original request in this circumstance. The main difference is, and it was honestly answered by my learned friend, that it would entail different complaint rights and in turn ultimately appeal rights. But as is commonly encountered and considered in the context of public law, there is an appreciation that the public authority should have the chance to have the first decision, and there shouldn't be remittals, unless necessary, some way up the line, because as said by Lord Justice Sullivan in Burkitt, the role of that reconsideration provision is to correct. And so it's important that that a fresh request is made in order that if anything goes wrong with it, there be that opportunity to mark your own homework effectively before facing court proceedings effectively, or a complaint to the regulator. So that really becomes another reason why there must be a distinction between the original request, 5, and the reconsideration request. We agree with the points made about Regulation 4 and Regulation 8 and the charging power, and Regulation 11.3 regarding free of charge. It was suggested by my learned friend in response that that's just the beginning of it, but ultimately to comply, if you discover that you've failed to comply previously, that's then done under Regulation 5. But one can see that under Regulation 11.5, it's self-contained, and Regulation 5 provides the remedy, all within Regulation 11, to disclose what you found you should have done the first time round. As to the point about the answer to my point ultimately about how if it's not pegged to the date of the request, then ultimately you're having to scrabble around and work out what you have recently acquired close to the end of the 20-day statutory period. The suggested answer being you can rely on manifestly unreasonable, an alternative exemption. That wouldn't be open to a public authority because the request wouldn't be manifestly unreasonable. The timing of the request wouldn't make it manifestly unreasonable. And when would you set it? When would it become manifestly unreasonable? After 10 days of the 20 days? 15, 19? Regarding the point made by Lord Justice Dove about Regulation 14 and the provision saying that where you rely on one of the exceptions, you must say so effectively, and that there is this notice requirement. And that perhaps could be why the utility of 12.4a. As I've already said, if it's outside scope because not held at the date of request, you effectively don't need 12.4a. And as to 12.4a being useful in order that there be a duty to notify the requester so you know we're not providing X because we didn't have it at the date of the request. The requester should already know that. Certainly, hopefully, after the court confirms the meaning of the regulations, that the information that will be in scope will be that which exists at the date of the request, and they will, and particularly if in light of as in this factual context, an ongoing investigation, they will know that more information may be inquired subsequently, and that would be the case also even after an internal review, reconsideration decision on my friend's analysis. They will know more will come afterwards. So ultimately, you don't need to have a refusal notice saying, by the way, there's more information, because almost inevitably in that context, more information is being acquired. It's perfectly easy for the requester to simply, if they know the trial or the investigation or anything else is ongoing, to just send another email. Those are all my reply points. Thank you.
Mr. Metcalfe, do you wish to reply?
Yes, my Lord, I'm grateful. If I could first just ask to hand up 3 copies of the Code of Practice on Environmental Information Regulations. This was referred to from a question from my Lord Lewison.
This is Regulation 16, is it?
That's correct, my Lord. And I'm not going to ask or take you through it, but the relevant or the reference is page 20, paragraph 60, which refers to the Regulation 11 procedure. Now, my first point,
Page 20, you say?
page 20, paragraph 60, which is at the bottom, and that refers to the Regulation 11 procedure.
Yeah.
In relation to Mr. Lockley's submissions, he says, first of all, that the regulations and FOIA are different regimes and that you should not hesitate to reach a different conclusion if that is where the wording leads you. We entirely agree. The wording in this case, however, does not lead to a different conclusion. Indeed, there is no textual support of any sort for Mrs. Hanlon's conclusions. Mr. Lockley relies on the purpose of the regulations and the directive, which is to make environmental information available as widely as possible, but that does not require you to read Regulation 11 in such an open-ended and burdensome manner. The courts should adopt an interpretation that facilitates access, but also one that facilitates information being made available as soon as possible. And the presumption of disclosure in recital 16 of the directive and the presumption under Regulation 12.2 is not an open-ended license to rework the entire regulation. The fact that the Court of Appeal in Montague found that Regulation 12 of the regulations does not aid the interpretation of Section 2, subsection 2b of FOIA is perfectly coherent, but it doesn't support a general conclusion that the two instruments cannot inform one another. And there is no better illustration of this than what Lord Neuberger says at paragraph 73 of Evans, referencing what Lord Justice Sullivan concluded in Burkitt. Even though the schemes are different, they can assist one another, and they have assisted one another. And the read across in this case is explicit when we look at regulation, subparagraph 1, which transposes the provisions of parts 4 and 5 of the Act, FOIA, and essentially applies the same mechanics with only consequential amendments to appeal complaints to the Commissioner and appeals to the Tribunal in relation to the regulations. A further point which Mr. Lockley raised is that the duty to provide up-to-date information under Regulation 5, paragraph 4, he implies that this means that supports his conclusion of the Regulation 11 being of continuous effect. But of course, the ordinary meaning of up-to-date means up-to-date as of the date of the request. It doesn't mean give scope to information which was created after the date of the request. Taking up my Lord Justice Dove's point as to the benefits of a refusal or the purpose of a refusal under Regulation 12.4a, it communicates information to an applicant. We agree with that. It is not redundant. There is the obligation under Regulation 14 to issue a refusal notice and set out reasons, and this provides a valuable function under the regulations. A public authority has a duty under Regulation 14 to give a reasoned response, and that's particularly important to bear in mind that there are often meaningful disputes, substantive appeals under Regulation 12.4a and the corresponding provisions of FOIA, because a public authority will often say that it doesn't hold any information within the scope of the request. And the requester turns around and says, in point of fact, you do, or you must, by praying in aid other information which is in the public domain or which the public authority has already put into the public domain and doesn't realise. And in those situations, the Commissioner and subsequently the First-tier Tribunal is put to a factual investigation of determining whether or not information is held on the balance of probabilities. But that entire possibility, that entire avenue of appeal is only possible because the requester knows in the first place that the public authority's position is that there is no information within the scope of the request, and that then becomes the basis for an appeal. That's a conclusion that can be appealed and often is. I also agree with what was said by my Lord Justice Holgate, that Regulation 10, the power to transfer a request under Regulation 10.1, is only meaningful if held is not concerned with the continuous precedent. It's otherwise, in my submission, quite a draconian way to cut short a request, because you are to cut short a request when one thinks of all the obligations that come with having to deal with a request under the regulations, as with one under FOIA, to be able to say, well, it's not our problem, go and point to a different public authority. In effect, the way that one reads Regulation 10 means that ends the involvement of that particular public authority. So one suspects it would still be open to an applicant to make a request for reconsideration. But the way that Regulation 10 is drafted effectively means that it becomes a new request to be dealt with by the next public authority, no longer the previous public authority's problem. Mr. Lockley says that an applicant can use regulation to say, in effect, your previous refusal is no longer valid because of the circumstances have changed. But of course, the trigger under Regulation 11, paragraph 1, is that the applicant, it must appear to the applicant that the authority has failed to comply with the requirement of these regulations in relation to the request. Not that it is a particularly justiciable point, but surely an applicant saying your previous response was valid, it contradicts what is required by Regulation 11.1. And Mr. Lockley says it would only apply in limited case where circumstances have changed, but the truth of the matter is circumstances are always changing. It may not always be appreciable in a period of days or weeks for a public authority, but there are certainly enough cases involving FOIA and the regulations in which circumstances do meaningfully change over such a period. The additional point that Mr. Lockley made was why make a new request when you can simply get the new information by way of reconsideration? A short answer to that is that simply is doing an awful lot of work in that particular sentence. If Mrs. O'Hanlon is correct, then the public authority doesn't just have to look back at the work that it has already done in relation to dealing with the request. It in effect has to retake the entire decision again with all the work that entails. And my submission is that is considerable. Lastly, the point that Mr. Lockley made concerning evidence and the date of original refusal. We say original implies the existence of other refusals subsequent to the first, and obviously you take the first, and that is consistent with the existence of internal review, which is now a standard feature of the Freedom of Information Act, even if it isn't mandatory. Unless you have any questions, my lords, those are my submissions.
Thank you very much.
My lords, I had a final point that I was told to, it was asked, could we look into just a factual point regarding whether the actual index information, the notices of contravention sent to AMARC were amongst the original request and how they came to be an issue. From looking back over the papers I have, it seems that in the respondents' closing submissions, reference was said broadly, reference was made, there's no reason to withhold any of the notices of contravention for this site. Now, that could be referring to the ones sent to the duty holder, but it's broad enough to say, to be, as it says, any, to include the ones sent to AMARC. And then the next relevant step was that in the permission to appeal decision by Judge Citron, he expressly identified notices of contravention along with other things.
When you say closing submissions, that was in the
FTT. FTT. So the ultimate outcome of that, my lord, is that there was no point that we would take now or did take or could take, but about it not being in issue once the Upper Tribunal found that it wasn't a itemised list, but rather everything within that opening broad paragraph.
But it came to light because of evidence HSE produced for the purpose of that appeal.
Yes, yes, and then in the closing submissions, on a generous reading, the respondent then referred to it and sought it.
Thank you.
My lord, I also took instructions on that point. My client's position was that she was not aware of those additional documents until she read the First-tier Tribunal decision. It may be that it was possible to become aware of them from the witness evidence, but that was her position in my instructions.
Right, well, thank you very much. This case has had permission to appeal because it raises points of importance. So particularly at this hour on the day, it won't surprise you to learn that we will reserve our decision. You will get a draft or drafts in the usual way electronically. They come with a fierce embargo, which means what it says, so they can only be shown to those on the distribution list. The receipt of the drafts will be your opportunity to correct our English, but not to raise new arguments, nor to disagree with our reasoning. We would hope that in the light of the drafts you will be able to agree an order disposing of the two appeals. If you can't agree a form of order, please make short written submissions and we will make the order that we consider to be appropriate. The eventual hand down itself will be electronic by distribution to the parties and released to the National Archives, so there will be no need for any further attendance. Thank you all very much.